before the noon hour. Is Judge Mester still here? You're going to wait until after? Okay. All right. Peggy Raben, Criminal Defense Attorneys of Michigan. Do you have your red light on there? Press the button.
Thank you.
Thanks.
Good morning. My name is Margaret Raben. I am the former president of Criminal Defense Attorneys of Michigan, and I am currently the co-chair of their Rules and Laws Committee. What I would like to say today is that it's very clear that the Miller decision says that mandatory sentences of life without parole for juveniles are cruel and unusual punishment because they are mandatory. There was no consideration given to anything except the conviction. If there is an assessment of the person under 18 for purposes of sentencing, then life without parole can still be imposed. And what we know scientifically and as human beings is that young people, and 18 is arbitrary, 25 would be arbitrary, all right? But we certainly, if we're going to draw a line, 18 is the line that the Supreme Court has drawn. And we know that young people are not mature. They are not responsible as they're going to be as they mature. And they are not thoughtful about consequences. And these are things that a judge would traditionally consider when she was going to sentence someone. And what Miller has said is that she must consider that in sentencing a juvenile, and she must consider it in a very specific way. And that's what's missing from the Michigan system. If juvenile life without parole, mandatory juvenile life without parole, is cruel and unusual prospectively, then it was cruel and unusual in the past. And that's the question. It's not a question of a technicality. It's not a question of procedural. It's not a question of substantive. It's a question of fairness, of looking at what has happened in the past, looking what the direction of the Supreme Court is for the future, and deciding what are you going to do about this discrete group of young people, many of whom are no longer young. They're in their 30s, they're in their 40s. They grew up in prison. And under current sentencing, they are going to die in prison. And no one is ever going to take a look at the person they've become, because all we're stuck on is the dopey kid they were at the time they committed their crime. We've talked about justice. Justice is for all, not just justice for the victims, but justice for all. There's a difference between being convicted and being sentenced. Nobody is talking about revisiting convictions. All we're talking about is the opportunity for someone to take another look at the sentence. And we're talking about real people. We're not talking about prosecutorial discretion. We have 83 prosecutors in Michigan. Every single one of them gets to look at every single case and decide what charges they want to pursue. We're not talking about interfering with that. The AG said that to be in prison in Michigan, you have to do something repeatedly. That's not true. That's not what we're talking about. We are talking about young people who did horrible things because they're stupid, impulsive kids, and never taking another look at that. I would like to point out that the legislature has dealt with the issue of changing mandatory life without parole sentences before. And it was in the context in 1998 and 2003 of amending the Public Health Code sentences for the most serious drug crimes in Michigan. There were years from 1977 forward, 21 years, of mandatory life without parole sentences in Michigan for drug crimes. And in 1998, the legislature agreed to look at that issue. And in 98 and in 2003, the legislature amended the Public Health Code to do two things. First, eliminate mandatory life without parole sentences prospectively, all right, and impose a minimum term of years, all right, as an option to parolable life. But then they also amended the parole statutes to grant parole retroactively to people serving those mandatory life without parole sentences. And you know what? The world didn't end. Michigan continued. People became eligible for parole as they served the now new minimum sentences retroactively. People became eligible for parole. They appeared in front of the parole board. Some of them were never paroled. Some of them are still there because they write me every 6 months wanting to know what's going on. But many of them were viewed as the parole board as good risks. They were paroled. They have become productive members of the community. And you are not writing on a blank slate. You have done this before as a matter of fairness, as the matter of looking again at earlier decisions. And on behalf of the juvenile, now adults that I represent who are serving mandatory life without parole, I hope you will make the right decisions to fix this. Thank you.
Thank you very much. I do have a question for you. Clearly, we do not have direction from the Supreme Court on the issue of retroactivity, and there's certainly it's position of the Attorney General that that we wait until such a decision is ever rendered. Between now and that point in history, if we were to go forward as a legislature and require resentencing hearings, only to have the Supreme Court declare that that was not necessary, in your opinion, what does that do to the process? What does that do to the people who are subjected to that resentencing hearing? Both the not just the victims, but also the individuals themselves, the convicts, if you will. These individuals who feel that they would be eligible for a parole or get a resentencing hearing only to find out that was an exercise in futility. I mean, wouldn't it be prudent to wait, is my question? Wait for the Supreme Court?
No, I don't think so, because whatever decision the Supreme Court makes, all right, if the United States Supreme Court or the Michigan Supreme Court determines that the Miller requirements are retroactive, you are bound by that. But if either of those courts determines that the Miller requirements are not retroactive or actually retrospective, you are not bound by that. You can look, it is what is entrusted to you is the problem created by the Miller case, which says people who got mandatory life without parole sentences when they were under 18 are serving cruel and unusual and thereby unconstitutional sentences. The Michigan parallel term to the Eighth Amendment is not cruel and unusual, it's cruel or unusual. So as far as Michigan is concerned, you've got it both ways. You can certainly choose to do nothing about that. But if we're talking about justice, if we're talking about fairness, I don't know how you can refuse to do something right now.
Thank you. Representative McBroom.
Thank you, Mr. Chairman. I want to make sure that I understood what you were saying correctly. So I'm not trying to put any words in your mouth, so you can correct me if I misunderstood you. But do you believe that all of these people who are sentenced to life without parole as juveniles, do you believe that none of them are fully culpable for their crimes because of their youth and impetuosity? I mean,
Are you asking me personally?
I thought that you seemed to have said that they all needed these extenuating circumstances due to the youth, and that, you know, they made stupid decisions and they were young and dumb and whatnot. Did I misunderstand you when you said that?
I don't know. Well, I believe every single one of them deserves an opportunity to have the circumstances of their crime and the circumstances of them reassessed,
Okay.
all right, under the parameters set forth in Miller.
But you're willing to accede that some of these, even when they were 16 or 17, were very calculating and very well understood what they were doing. And, I mean, I understand. I mean,
I'm not foreclosing
Okay.
that as a possibility. I raised 3 boys, and my husband and I considered it the most significant thing we did is that none of them have felony convictions. So but there were times.
Okay. I just wanted clarifying on that. Thank you.
You're welcome.
All right, thank you very much. Any other questions from House members? Hearing none, thank you very much for your testimony this morning.
Welcome.
What we're going to do now is I'm going to stand at ease, and we will break for an hour and a half and reconvene here promptly at 1:30. Thank you.